All right, folks, it looks like it's 2 minutes after, so I think that even though other people are still joining, we're going to go ahead and delve in because we've got a relatively short program today. So thank you right off the bat for joining us today for this webinar. This is navigating the interplay between leave laws with a focus on the FMLA and the ADA. My name is Katherine Brustowicz, and I'm an associate attorney with the Wagner Law Group. I specialize in HR and employment law. I handle a lot of leave law issues for my clients, so I'm really thrilled that you've all tuned in this afternoon. And I'm joined today by David Gabor, who's a partner and is the head of our HR and employment law practice here at the Wagner Law Group. Hi, David.
Katherine, and thank you all for joining us.
Awesome. So we're very excited for this interactive webinar. And so with no further ado, let's go ahead and jump right into the agenda and see what's in store for us over the next half an hour.
Okay, thank you, Katherine. If you can jump, there you go. So we're going to talk a little bit about the Family Medical Leave Act and the ADA. Just a bit of background and context before we delve into 5 scenarios that we created based upon issues that have arisen that have challenged our clients and cases we've read about. And after that, we're going to have our famous top 10 list of takeaways. So grab your writing sticks and let's get cracking. Katherine, can you talk about the Family Medical Leave Act, please?
Gladly. I don't have a writing stick, so my laptop keyboard is going to have to do. So as David mentioned, I am going to delve into some of the higher level requirements and criteria with respect to both the FMLA and then with the ADA. And then once I do cover some of that foundation, we'll get more into the interactive aspects of our scenarios. And we'd be happy to answer any of your questions as they come up. So feel free to utilize the Q&A chat function there. So the Family Medical Leave Act applies to private sector employers who employ 50 or more employees within a 75-mile radius, as well as all public employers. An employee becomes eligible for FMLA leave if they've worked for at least 12 months and 1,250 hours in the previous year. Under the FMLA, an eligible employee is entitled to unpaid leave for any of the following reasons. And those are the 4 reasons that are outlined here on the slide. 1 is for the birth of a child and to care for the newborn child. For the placement with the employee of a child, for adoption or for foster care, to care for the employee's spouse, child, or parent with a serious health condition, and because of a serious health condition that makes the employee unable to perform the essential functions of the employee's job. Now, I did want to note that the DOL's view of the legislative history is that the meaning of serious health condition is very broad. So it's intended to cover various types of physical and mental conditions. It's intended to cover conditions or illnesses that affect an employee's health to the extent that they must be absent from work on a recurring basis or for more than a few days for treatment or recovery. Now, of note, the FMLA's definition of a serious health condition is broader than the definition of a disability under the ADA. A serious health condition actually encompasses conditions such as pregnancy and various illnesses, injuries, impairments, both physical and mental, that require multiple treatments and intermittent absences. So that brings me to the last bullet point on this slide with respect to the DOL guidance. This past May, and in an effort to increase awareness of both FMLA rights and mental health awareness, the DOL issued new FMLA mental health resources. The publication's take-home message was that no FMLA eligible worker should ever worry or hesitate to request time off due to a serious mental health condition. The updated guidance is available on the DOL's website, and it is a helpful resource. So I wanted to ensure that you're all aware of that. Easy to think about a serious health condition as maybe only being physical, but we can't forget about mental health. The FMLA allows eligible employees up to 12 weeks of unpaid but job protected leave per year for the qualifying reasons that we just discussed in the previous slide. Under the FMLA, upon return from leave, the employee is entitled to be returned to the same position that they had prior to their leave, or to an equivalent position with equivalent benefits and pay. The reinstatement of an employee after an FMLA leave should be to a job with similar duties, similar responsibilities, similar status to the previous one. It should be to the same geographic area, and generally the employee is returned to the same shift or the same schedule. Now, speaking of return to work, there may be limitations on the employee's return after their FMLA leave. For example, if the employee is unable to perform an essential function of the position due to physical or mental condition, or due to the continuation of a serious health condition, the employee has no right to restoration under the FMLA. However, the employer's obligation may at that point become governed by the ADA. It may be appropriate to enter into the interactive process to determine whether there's a reasonable accommodation that might enable the employee to perform the essential functions of the job. We'll delve into this when we get into the ADA, and also when we'll review this when we run through the various scenarios shortly. Now, in addition, should the employee return from FMLA leave, an employer may transfer an employee to an alternative position in order to accommodate intermittent leave or reduced leave schedule. It's important, however, to note that under federal law, there's no requirement for the employer to allow intermittent leave. Now, that being said, most state laws do require the allowance of intermittent leave. So please make sure to stay up to date with your state and local laws as well. Now let's change gears a little bit and move over to the ADA. The Americans with Disabilities Act prohibits workplace discrimination against people with disabilities and requires employers to provide reasonable accommodations to workers and to job applicants with disabilities. The ADA applies to employers with 15 or more workers. Remember, the FMLA is triggered when there are at least 50 employees within a 75-mile radius. The ADA is just 15 workers. The FMLA's definition of serious health condition is not the same as the ADA's definition of disability. An ADA disability is an impairment that substantially limits one or more major life activities, having a record of such an impairment or being regarded as having such an impairment. So the ADA applies to individuals with a qualifying disability. For example, pregnancy is not considered an ADA disability unless the person is experiencing complications that impair or limit one or more major life activities. Now, keep in mind that the ADA does not cover employees who need time to take care of a spouse or a family member who needs surgery or who's suffering from an illness. That's more of the FMLA bucket. So on to reasonable accommodations. A reasonable accommodation is any change to the job, to the work environment, or to the application process that would allow an individual with a disability to perform the essential functions of their job. Reasonable accommodations vary, and they're very circumstance and fact specific. Some examples could be maybe a workspace accessibility issue or equipment adaptation, or maybe schedule or shift adjustments. But in order to determine whether a reasonable accommodation is available without causing an undue hardship to the employer, it's imperative that the employer engage in the interactive process. So this is essentially a conversation or a series of conversations with the employee to ascertain what sorts of changes or modifications to their job could be implemented to allow them to do their job. Leave may be required if it would constitute a reasonable accommodation that doesn't impose an undue hardship on the employer. Leave typically must be for a defined period of time and is unpaid unless the employer pays for other similar leaves. Of note, unlike the FMLA, there is no set leave period that's mandated because accommodations, of course, depend on the individual circumstances. They should generally be granted unless doing so would result in an undue hardship to the employer. Now, I did want to mention two quick practice tips. First, the state where the employee is working may have similar requirements, such as the interactive process. And those requirements might apply to employers who have as few as 4 employees. So again, make sure you're up to speed with your state and local laws. And secondly, can't overemphasize the importance of documenting the interactive process. This documentation can absolutely become exonerating if a discrimination claim is ever brought against you in the future. We'll talk a little bit more about that, excuse me, in a few slides. David, did you have any other practice tips that you wanted to discuss?
I do. Thanks, Catherine. The issue of documenting is so very important because too often Catherine or I wind up in court and the judge says, well, where's your record of the interactive process? And we don't have it. But there's another thing to think about, especially now when we've got so many people who are having trouble filling positions because of the Great Resignation in so many different industries. That puts managers and supervisors under a lot of stress to meet deadlines, expectations that a client or a customer has to staff restaurants, supermarkets, other types of retail businesses. So when an employee goes to a manager or supervisor and says, I need some time off, and the manager or supervisor is thinking, how am I going to get my work done? How are we going to staff so we're open or meet a deadline? The problem is if the manager or supervisor is thinking about that under stress, their reaction may be to say, no, you can't take that time off without checking with HR about how to best respond to that. So if you have a situation where you think there's a risk that your managers are under stress or not properly trained, make sure they know to go to you before you respond. And we will have a scenario that kind of covers this issue in a few minutes. So Katherine, let's jump into the first scenario.
Perfect.
Okay, so Marty McFly, winces when moving heavy boxes at work, and he works for a tool and die company known as Hill Valley Tool and Die. He's been with the company for 10 months, and he's been a really good employee, even with his wincing. But beginning last week, he slowed down quite a bit. And he's not one to explain, but his boss, Biff, wants to write him up for poor performance. And Katherine, this is a heavy fact pattern. Sorry for the Back to the Future pun.
What, is there a problem with the Earth's gravitational pull?
Touché. So what should Goldie Wilson, the mayor, do?
Well, thanks, David. This is actually a great scenario. So right off the bat, it's pretty evident that Marty may need a reasonable accommodation, right? Even though he hasn't asked for one, it's been noticed by his employer. And that's a really important point because an employee need not explicitly request a reasonable accommodation. The onus is on the employer. So it's if the employer knew or should have known that there's a disability at play here, they have the duty to really start to engage in that interactive process and see if they, together with the employee, can come up with a reasonable accommodation. So to that end, I would say that Biff or Goldie should engage in the interactive process with Marty. Maybe it's possible for Marty to have some kind of a weight restriction on the boxes that he's lifting, or maybe he needs to wear a knee brace or a back brace when lifting the boxes. But Biff and Goldie would never know what that potential reasonable accommodation would be if they don't start the interactive process. I'd say also at that point, after engaging in this process, they should weigh the options of a reasonable accommodation against a potential undue hardship to Hill Valley Tool and Die. Anything else that you would recommend, David?
Yeah, before we jump to the next scenario, I would add that it's not necessary for the employee to officially request an accommodation to be protected under the ADA.
Right.
Okay, so let's jump into the second one.
Okay, great. So here we have Ray Bork, who's been out on leave. And Revere Sports has a policy that's far more generous than what's required under state and federal leave laws. Ray has only 1 week left on his leave, and he receives a letter from Revere advising him that, quote, You are welcome to come back if you can perform all of the essential functions of the job. David, do you see anything wrong with this situation?
I do, and this has come up a few times. The EEOC has made it quite clear several times, and in practice guidance is going back about 11 years. It's important that every time you communicate with the employee, where you mention they're able to come back, include the words with or without a reasonable accommodation. The EEOC is very stringent on that requirement. And this is one of those times where you get an intersection between the FMLA and the ADA, because you could be out on family medical leave, getting close to the end of a 12-week period, communicating with the employee on family medical leave when they have a right under the ADA for that language, with or without a reasonable accommodation. Katherine, anything else on this one, or do you want to jump forward?
Yeah, I'm going to jump forward. That was the main practice tip that I was gonna echo, that it's really important whenever you're communicating with an employee about leave, it's really important to add that last little bit about the reasonable accommodation.
Okay, so here we've got George. He's a 5-year veteran controller, and he took family medical leave for 30 days after having surgery. During the leave, his manager, Potter, decides that his position should be eliminated, but he can come back to work as a receptionist. So going from controller to receptionist. Mary, who's the CEO, wants to go along with the plan. And now they head over to Bert, who's the head of HR. And I should say that I heard that Clarence said that no man is a failure who has friends. Speaking of friends, Katherine, what would you tell Bert to do?
Thank you very much, David. Clarence was a wise angel. So in terms of this scenario, I'd say that the first issue that really jumps out to me is that George is out on job protected FMLA leave, and Potter wants him to come back, return to a job that's not at all substantially similar to his protected job. So a controller and a receptionist, they have very different duties, very different qualifications, and most likely very different pay structures. So the take home here is that Bert should not go along with this. Potter's behaving in a patently unacceptable fashion. Maybe he's got a vendetta against George, but this is not something that you want to do to your employees. You don't want to switch up their job position to this extent while they're on FMLA protected leave. David, did you have anything else to add to this one?
No, I think we've got it covered.
All right. This next scenario is juicy. So Janice tells her manager, Helen, that she needs to have a sugary substance with her at work because of low blood sugars. Helen denies the request. Janice gets a low blood sugar and drinks an orange juice. She pays the $1.89 for the juice, but she gets fired by the manager and loss prevention anyway. What should Helen and the company have done, David?
Well, first of all, I think that Janice probably felt that she was squeezed in that one.
Oh boy.
And this is actually ripped from the headlines from a real case in Tennessee a few years ago involving a company called Dollar General. If there's anyone from Dollar General on the webinar, I apologize. But here's what should have happened. She requested that she have the accommodation of having something sugary with her. The manager really should check with HR and say, what do we do? And this goes back to one of the practice tips we had earlier. How do we respond to her? And the proper response would be, yeah, have her have something with her, because if she has a low blood sugar, she needs to correct it right away. And it's not an unreasonable accommodation for her to have that blood sugar. What happened in the court case is that the court found in her favor, because there was no interactive process, there was no attempt at a reasonable accommodation, and there was retaliation for her having requested the accommodation. By the way, in the real case, she had the receipt. She paid for the orange juice. She paid the $1.89, and she had it in her purse when loss prevention came in with her manager, and she got fired. We went through the circuit court, and this cost Dollar General more than $750,000. And that was a preventable mistake, which is so frustrating because we see it happening far too many times. Katherine, any other tips on this one?
Yeah, I was just going to say that, Janice having had this orange juice was in no way an undue hardship to the company. She actually paid the company some money to purchase this orange juice. But this really is just a very egregious real life situation of really what can go wrong when HR and management's not properly trained and isn't prepared for this type of a request for a reasonable accommodation. So thank you for sharing that one with us, David.
Okay. So any of you people like Star Wars? Anakin has been employed by Mos Eisley Cantina for about 11 months. Remember, 11 months. And he's got some surgery scheduled to take place 2 months into the future. And Chewbacca does not take it very well and wants to fire him. So Yoda, who's the head of HR, wants your guidance. Katherine, may the force be with you. What do you tell Yoda?
So first of all, we need to take a pretty close look at the timing here. So Anakin would be entitled to the procedure because by the time that surgery rolls around, he would have been employed for 13 months. But it would also be important to calculate whether or not he meets that 1,250 hour threshold. We don't know from the facts that David shared with us how many shifts he's worked at the cantina. We don't know if he's full-time. Maybe he's only had 1 or 2 shifts over the past calendar year. So that would be an important question for Yoda to ask. And I would say that Yoda would also be quite wise to heed our guidance of talking to Chewbacca, talk him out of firing Anakin. That would be a poor decision based on the facts that we're aware of here. And David, did you have anything else that you wanted to add to this one before we move on to our top 10 takeaway points?
I think it's, this is a question of it could also be a reasonable accommodation to let the person have the time off for the procedure as well.
Right.
And one other thing that's taking away the law and getting to the business side, best practices. If you deny the request, and let's say you were to get rid of a person and maybe, the cantina only has 45 employees, so it wouldn't fall under the Family Medical Leave Act. What's the impact on employee morale, employee engagement? Would other people follow suit and walk out the door because they felt that the company was unduly harsh? So shall we jump into the top 10?
Absolutely. That was a very good practical tip there, David. All right, here's our top 10s. David, did you want to start off on this one?
Sure, thank you. In addition to what Katherine had said earlier, when an employee is on FMLA leave, the employer must continue health insurance coverage as if the employee were not on leave. Upon return from the leave, most employees must be restored to the same job or one nearly identical to it with equivalent pay, benefits, and other employment terms and conditions. An employer may not interfere with an individual's Family Medical Leave Act rights or retaliate against someone for using or trying to use family medical leave. Opposing any practice made unlawful by the Family Medical Leave Act or being involved in any proceeding that under or related to the Family Medical Leave. That's taken from the guidance from the Department of Labor. So the big takeaway on that really is the benefits the employee has in addition to holding the position open or something that's substantially equivalent. Katherine, anything else on that one?
No, I think you really covered that one quite beautifully. Well done.
Well, thank you. Now, the second one we had here, if I may take this one, is retaliation. And it's so important to keep in mind, retaliation isn't just when the employee is right. Yes, I am covered under the Family Medical Leave Act. Yes, I am covered under the ADA. It's enough that the employee reasonably believes that they're protected under either of those statutes, or for that matter, Title VII or the ADA. If the employee reasonably believes they're protected and they make a request for leave or an accommodation, and they have an adverse employment action that's taken within 3 or 4 months, that's a prima facie retaliation case. And if you ask any judge in state or federal court, they will tell you retaliation is much easier to prove than discrimination. So Katherine, if you want to jump into point 3.
Sure. I'll try to be brief because I just noticed that we are running a little bit short on time. But number 3, safeguarding privacy regarding medical records. So medical records should absolutely be kept separate from the personnel file. And the ADA requires employers to treat any medical information that they obtain from a disability-related inquiry or any medical information that is voluntarily disclosed to them by the applicant or by the employee as confidential medical records. Now, employers may share such information, but only in very, very limited situations. And that would be with managers or supervisors, first aid, or some type of a safety personnel, or of course a government official if they were to be investigating compliance with the ADA. Our 4th takeaway here is that managers need to be ready for requests and questions. So managers should be prepared before they're faced with their first leave request or first request for reasonable accommodation. Think back to our scenario with Janice in the orange juice. That was a completely avoidable situation if only Helen had been properly trained. And then also remember how very vital documentation of the interactive process is. David, did you want to take number 5?
Sure. When preparing for the interactive process, make sure that you've got a good line of communication with the employee. Anything in writing, explain the process, what the interactive process is, what you expect of the employee in the process, what you're going to need from their healthcare practitioner if necessary. Make it very clear, in your communication. Before you go into the process, understand the person's role, the responsibilities, the division they work in, and then also explore what types of accommodations are available for the person before you get into the process. Okay, and then number 6, and we said this before, but it's worth writing down if you didn't before, and that is make sure that you tell people you can return with or without the reasonable accommodation. We just stress that because it's something that's missed so many times, and we're just hoping that everyone gets that one right. Katherine, okay, I think I have 7 also, on interviewing people with disabilities. The ADA protects job candidates, not just your employees. So candidates for jobs. When someone comes in for an interview and you think they might have a physical or a mental limitation or protection, don't ask questions that you would not ask of anyone else. You can frame it, this is what your job requires you to do. Is this something you're able to do? But don't make any references. You see they have a limp, you see that they might have a bad back, you think they might have a hearing issue, or whatever else. Don't reference that when you interview. Try to give the same interview to them that you give to everybody else. And if you're unsure, that's a good one to talk to an attorney about before you start interviewing somebody who's got an issue. Katherine?
Yeah, that's an excellent point, David. Thank you. So your point actually ties quite nicely into number 8 here, that ADA protection applies as early as when an individual is applying for a job. So under the ADA, an individual is covered during the interview when somebody is applying for the job as well. And then, of course, also if the individual is hired. It's important that employers also recognize that ADA website compliance is very important during the application process. This is especially true if the only way for people to apply for a job with your company is online. Could a blind person using adaptive technology navigate your application process? They should be able to. Otherwise you might be in violation of the ADA. David?
Well, thank you. I wanted to talk about pregnant workers because I do get the phone call now and then saying we've got a person, we want to get rid of her. She's not been working very well. Have you had prior problems? No. Discipline? No. Warnings? No. Anything changed? She's pregnant. And remarkably, I've been practicing for more than 30 years. God, I hate to admit it, but this has come up at least a dozen times. You can't get rid of somebody because they're pregnant. That's just a foolish thing to do. Think about accommodations so that they can work through the pregnancy and have the position available when they're ready to come back to work. but don't think they can't work as well or as hard. And as I alluded to earlier, if you do not make allowances for somebody who's pregnant, you probably can have a lot of pushback from other employees. So Katherine, the D word, documentation.
Documentation. So documenting the interactive process. David and I have both mentioned this a few times now, but it really is very, very important to document the interactive process. Remember that an employer is not actually required to allow an accommodation if, after engaging in the interactive process, it's determined that there is no reasonable accommodation or modification that would allow the employee to perform the essential functions of their job without causing an undue hardship to the employer. So if that's the case, and then an employee sues the company, the documentation that you have proving that the company engaged in good faith in that interactive process, that can ultimately be exonerating to the company. David, do you have anything to add to this last point here?
No, I think we're set. Thank you, Katherine.
You got it. So that brings us to the tail end. We did make it just to the very end of the time. So if anybody has any outstanding questions, you should feel free to reach out to me or to David. We have both of our direct lines on this slide here, as well as our email addresses. We'd be more than happy to go back and forth if you have any kind of questions or legal concerns. So thank you again for your time today.
Thank you, and have a very good rest of your day. Take good care.